we go. Hello, everybody. Hi, hi. I am going to let people in. Admit, admit, and admit. Good morning, good afternoon. I'm going to let people come in a little bit. All right, welcome everybody to our Q&A with Trey Lawrence. So exciting, Trey. Thank you so much for being here. Oh my God, I can't even speak. I'm so excited.
No.
So excited for you to be here. While you guys are trickling in, I'm just going to do a brief introduction about Trey and kind of like a little bit of the rules of how the call is going to go. Everybody who's joining, please make sure you are muted. If not, I am going to mute you. So today we have a special guest in our mastermind, Mr. Trey Lawrence, and he is a very established individual. And I have to pull up his whole background expertise because I can't even say it just from my memory. There's so much. So let me tell you a little bit about Trey. Trey has served as the CEO of the American Association of Orthodontists for the past year. Prior to that, he was a general counsel for the ASL, we're here. And he was leading the AAO legal and advocacy teams, or heading the AAO legal and advocacy teams for the 5 years. Trey comes to the AAO after 18 years at Thompson Coburn. Am I saying it right?
Yep.
It's a law firm of approximately 600 attorneys that's based in St. Louis. Trey focused primarily on business and commercial litigation, product liability defense, class action defense, and regulatory law. Trey received his law degree from the Washington University in St. Louis and a master's degree from Harvard. Unbelievable. Everybody welcome Mr. Trey Lawrence. Thank you so much for being here. It is such a pleasure. Your time is so valuable, and we're just so honored that you're here and you're spending an hour with us and educating us on all the things in the dental industry, law related, and answering our questions. Just so happy to have you here. Thank you again so much for being here.
Absolutely. I'm happy to be with you guys.
So amazing. Okay. All right, guys. So let me tell you a little bit how the call is going to go. For those who are live, thank you for joining live. I'm muting everybody. Please let's stay muted for now. At the end, we'll be able to ask questions. In the meantime, as Trey telling us some news about law regulations in dental industry and some other topics that we're going to go over, if you have any questions, please feel free to put them in the chat. Just type them in the chat, or if you want to stay anonymous, just type them directly to me. There's a way in the chat to send it to everybody or just to me. And if you send it just to me, it's going to imitate anonymous, and then I will be able to ask those questions to Trey at the end. Okay. So what we're going to do is the meeting is recorded. It's going to be 1 hour long, and everybody will receive a recording within 24 hours. And we will start with Trey talking a little bit about the current legal landscape. Okay, so he's going to tell us about the recent changes in the dental law, about current hot topics, about common challenges that practices face. And then he's going to talk about a portion for dental associates, and then for portion for practice owners. And in the end, we're going to answer all your questions. Thank you so much for everybody who pre-submitted their questions. And if you have any questions, during this presentation, like I said, either put them in the chat, or at the end, you can unmute yourself and ask them live so we can have that back and forth. Sounds good? Amazing. All right. So let's talk a little bit. Trey, tell us what's going on with the dental industry, with the dental law. What are the current hot topics? What are the challenges the practices face? Fill us in a little bit, please.
All right. So where to begin? So actually, no, where I do need to begin. So I have to go into lawyer mode here right out of the gate and just give the standard disclaimer that I always give, that nothing that we talk about today or any questions that I answer, anything like that, should be construed as legal advice or legal representation. This is all purely for informational purposes. The ethics people make me have to say that before I start any session like this. So with that being said, So it's been an interesting time in the law as it relates to, dentistry in general, because there's not been a lot of major change in the laws themselves. So if you think about the way the law works, there's the law itself, but then there's how it's enforced. And then there's how like people run into or encounter new situations that the law hasn't considered before. So the laws themselves really haven't changed a lot. Really, the only area that directly impacts dentistry that there's been major changes in the law itself over the last few years has been non-competes, which I think we're going to get to later. So I won't steal that thunder now. Where there has been a lot of change has been in those other two pieces that I mentioned. It's on how the laws are being enforced, and then the situations that some of these legal questions come up in as, tech, and really in particular as technology develops. So I'll start with the enforcement one first. So one of the big things that's happening, so let me take a step back. Like when I talk about a lot of issues that impact dentistry in the law, like HIPAA law or employment law, or a lot of different topics, a question I get a lot is, okay, what you're saying is probably true, but who's going to catch us? Like, how are we really going to get in trouble if we do that? Like, who's going to catch us? And that's where I do think there has been some significant development, because we have really seen an increase over the last few years in enforcement of laws by some of the federal agencies. So in particular, HHS, which is responsible for enforcing HIPAA. There are a couple of noteworthy cases that have happened in the last couple of years where dentists were responding to online reviews, and they disclosed a little too much patient information when they were responding to the online review. And HHS found out about it and assessed some pretty significant fines against these dental practices. They had to enter what's called a compliance order, which is basically you have to check in with the agency and let them know you're still complying with the law. It's a big burden. So that's an area where, somebody that I think probably thought they would never get caught doing something has gotten caught. Another one has been the FTC. So there have been some cases. So it's very popular, as everybody knows, to use like patient testimonials, patient endorsements, and customer endorsements generally. And there have been some similar cases where the FTC has fined small businesses or healthcare practices for breaking the laws that relate to endorsements and how you use a patient endorsements. And we can talk later about exactly what those requirements are. But I think those are all cases where I'm certain when the practice did what they did, they had no idea they could get caught. So the question is, how is that happening? So one big way that the enforcement has really stepped up has been these federal agencies have gotten much better in using AI to like scan the internet and look for violations. So if you can picture the computer, the AI that's just sitting there running 24 hours a day can cover a whole lot more territory than, an individual, a person can, as they look for legal violations. So we have seen, and this is not unique just to dentistry or just to healthcare law. This has really been federal agencies across the board. There's been a really big increase in enforcement activity by the agencies because of the use of AI to scan the internet in particular. So having said all of that, I know a lot of federal workers are being laid off right now, and there's a lot of turmoil going on with the federal government. I don't know if that will continue. I mean, we may be sitting here a year from now saying that enforcement in all of those areas just stopped all of a sudden because they don't have any workers anymore. But that was definitely the trend that we were seeing before, at least up until these layoffs started happening. The other thing that's kind of related to that is another place where I've seen a lot more enforcement come about is, so if a patient has a problem with your practice, they don't know the law, they don't know what to look for. But when patients go and talk to lawyers, if, like, say a patient comes in with a complaint about the treatment they received, if I'm a lawyer that's talking to that patient, I'm going to get on your practice website, I'm going to get on your social media, I'm going to look at everything else that you're doing. And so that's another area where I'm seeing a lot more activity, is situations where, a patient, I'm sure, didn't go into the lawyer's office complaining about a HIPAA violation. They probably went in complaining that they thought, that practice should give them a refund or something like that. But then these lawyers are getting better and better at thinking to look on websites, thinking to look at social media, all of those areas. So again, that's another place where I think the enforcement is really picking up. So it's not so much a change in the laws themselves, but the enforcement of those laws, and where we're really seeing that. And then I think finally, I think related to all that, the other situation that I mentioned was when people encounter new situations that they have to try to play legal issues to. So social media is a huge one. I just think every day there are new ways that practices are involved in social media and promoting themselves on social media, or like say your practice has got a good healthy Facebook account and with a pretty good following, and then you start using Facebook Messenger to communicate with patients. Well, obviously that's not something practices were doing 5 years ago, but it opens a whole can of worms about HIPAA and communications having to be encrypted and all of those kind of things. So I think as practices are finding new ways to market themselves, new technology to use, all of those things, it creates these questions that we may not know the answer to until there's been some kind of there's been a court case, or there's been an instance where an agency has fined somebody that you really only then get a definitive statement on the law. So that's where that's where 90% of the development in dentistry law is going on right now. And it's tough because it's hard you can't just give kind of an overarching, like you can't give somebody a checklist and say, hey, do these 5 things and you'll make sure you don't run across any of that. What I think it does emphasize is that when you get into any new areas of practice, if it's a new type of, it's some new tool on social media, it's a new, even a new patient communication system, your messaging system or your texting system with patients, all of those things you have to make sure that you're thinking about, is there a potential legal issue here? Should I talk to a lawyer, have them take a look at this? Should I talk to our HR firm, whatever it is, and make sure that they look at it and make sure that you don't get into a problem, but kind of getting into that new territory that nobody's really explored previously.
Yeah, yeah. Wow. This is so good to know. And so I'm curious, you've mentioned how one of the ways how HIPAA has been violated is the doctors are sharing cases online with each other to get feedback.
Yes.
And
Yes.
so I'm curious, is AI able to get in our private Facebook groups, or how does that stand?
I'm not sure about that one. I know who can absolutely definitively get into a private Facebook group is if a lawyer has a subpoena. So that goes back to, this situation where a patient goes into a lawyer and complains about something, or they file a malpractice case. So, just for background, the area that's a concern here, it's a very common practice for doctors to get on private Facebook groups and trade information about cases. You post a case and you ask questions about it. And it opens up a lot of potential legal questions that we don't really have answers to at this point. So just to name a few of them, I mean, first of all, there's if you're posting any kind of pictures or anything that's potentially disclosing the patient's private PHI, protected health information, certainly you want to make sure, I think sometimes people assume when they're doing that, oh, I'm talking to other doctors, so this falls under the other treating provider exception of HIPAA. But that is definitely an unanswered legal question as to whether somebody, there's no question if you share information with the oral surgeon down the street because you need to consult on a case, that falls under the other provider exception. But just sharing with random doctors in a Facebook group, I'm not certain that falls under the other provider exception to HIPAA. So that would mean you either need to identify everything, make sure that faces are blacked out, all of those kind of steps before you do that. Another problem with even if you do think that you fall under the other provider exception is, can you 100% guarantee that everybody else in that group is a doctor? Is somebody's spouse walking by while the computer's open and they're getting a glimpse of your patient's picture? So that's a question. And then there's also some questions that are not HIPAA related specifically, but they're just related to malpractice. And this is where I got into this is why I mentioned the subpoena thing. If I post a case on a Facebook group asking for advice, and then that patient later sues me for malpractice, or there's a dental board complaint, a very common question is who name everybody that you consulted with on this case. Well, if I'm truthfully answering that question, I'm going to have to say, well, I posted it in this Facebook group asking for advice. So then that opens a whole different set of questions about, all right, well, now is there potentially some liability for everybody who commented on it? Or could I potentially be liable if somebody that I don't know other than just their Facebook group, I don't really know whether they're qualified to be giving me their recommendations or not? Did I commit negligence by relying on their recommendations? So to get back to your original question, I don't know if the federal agencies can use the AI to get into the private groups, but definitely if a patient ever goes and talks to an attorney, they're going to do that.
Yeah.
So none of that is to say don't post in those Facebook groups. It's just definitely an area to be aware that there's potentially some legal risks.
Yeah. So is there a way, because you mentioned, blurring the face, which we know, is there a way to, as safely as possible, because I know there's not quite regulations on that, to share cases? Because, a lot of the time, like in orthodontics, for example, right, there's not really standard of care. It's what a reasonable orthodontist in your area would do. So you kind of need to ask for other peers, right? If it's a challenging case. I think it's more responsible for a doctor to ask for help on the case, or not even take a case, rather than just be like, oh, I'll figure it out on my own. So if we do need to share a case with someone or want an opinion, and maybe we don't have like friends in nearby or stuff like that, is there a safe way to post them in a private Facebook group, like blur the face, maybe post anonymous?
Yeah, definitely making sure that you've properly de-identified everything. So, the pictures are the big ones, but then also, just make sure there's no other personal information. But for de-identification, the official HHS standard on de-identification is really complicated. So my kind of layperson's version is, if somebody who knew that patient looked at the picture, would they be able to recognize that it was that person? And so, that because I see sometimes like with just a block over the eyes, that kind of thing. And I think clearly anybody who knows that person and looked at that picture would be able to tell that's who it is. So just properly making sure you've thoroughly de-identified the case is going to be a big step. That really addresses most, if not all, of the HIPAA issues. On those more of the malpractice or the negligence type issues, I would just make sure that you're using common sense and taking anything that's said in response in a situation like that with a grain of salt. Make sure, I certainly wouldn't refer to it in the patient's chart or in a conversation with the patient, anything like that. You just want anybody who's looking back at, looking at whether you met with the standard of care in that case, to see that you were exercising your own independent judgment and you weren't giving a random internet opinion more credibility than it maybe deserved.
Yeah. Okay, got it. So maybe a little bit more than just eyes, maybe even like remove the ears and the hair as much as possible so that it's not identifiable. Okay, thank you.
Yeah. Here, I'll throw a really fun one out. One that I've actually seen people get caught on in the past is if there's some identifying mark around the mark. Like sometimes people have these like beauty marks and if it's unique enough, it is very possible that somebody who knows that patient could look at that picture and tell who it is. So that means sometimes not only blacking things out, you may have to go in with like Photoshop or something and do a little blurring or something like that. That's a little more advanced than kind of just standard slap a box on things. But that's why you always need to think through the lens of somebody who knew this person looked at this picture, could they tell who it is?
Yeah. That's so helpful. Thank you. Thank you for sharing that. Okay, so let's move on and talk a little bit about non-compete clauses and contract reviews for associates and employment.
Yeah, so the non-competes has been a fun one because there was a lot of activity in this area before the administration change, and now with the administration change, I have no idea what's going to happen. So everybody's probably aware, the FTC passed a ban on non-competes. It was retroactive, meaning that it wasn't only non-competes, from in the future moving forward, it was all existing non-competes. What then happens when a major regulation like that gets passed is that 1,000 people file a lawsuit over it. So you don't really know whether it's going to be enforced or not until until all of those lawsuits have had a chance to play out. The other wild card now is you also don't know if a new administration coming into the FTC is going to want to enforce something like that or not. There was a similar regulation that had been passed that required all small businesses to file these notices of, ownership of the company and who owned it and all of these things that typically are only reserved for publicly traded companies. And then the new administration came in and they said, we're not going to enforce that. So businesses don't need to comply with it. So all of that to say, there's a ton of uncertainty still out there about non-compete. So what I would definitely not do, like if I'm putting myself in the position of a resident that's just graduating or a young associate that's looking at a job opportunity and I see a non-compete in a contract, I would not just assume that that is not going to be enforced. Oh, well, I've heard these are banned. What if there's just so much uncertainty in what lies ahead that my rule of thumb with anything in a contract and definitely a non-compete is you always have to assume that whatever's written in the contract could and probably will be enforced against you, which means you need to get it to a point where you can live with it before you sign the contract. But I've heard, I mean, even before this non-compete ban came about, I would hear people give advice about contracts. And if there was a non-compete or something else that was in the contract, I've heard people say, oh, don't worry about that. That's not enforceable. You're never going to have to worry about that. And, here we just have no idea where the law is going to end up. So I would assume that any non-compete that is in a current contract or is in one that you're given to review and consider, I would just assume it is going to be enforced. So then that goes back to know what the law in the state where you're going to practice is. The states are all over the place. Non-competes generally have to be considered reasonable, as to scope and duration to be enforced, but that means something different in every state. There are a few states that have partial bans on non-competes, but even then, most of those states are pretty complicated. Like it's either under a certain income level, which generally is going to be, much lower than what any orthodontist or dentist is making. So know the law in your state. But then one other point on that is even if somebody gives me a non-compete, like say I'm in Missouri, somebody gives me a non-compete that's 100 miles in 5 years, which I know is, no court in Missouri is going to enforce that. If I leave that employer and they sue me for it, I can still spend a whole lot of money and a whole lot of time fighting that to get the court to finally agree with me. So actually, my brother-in-law is an insurance broker. He had exactly that situation where he signed a contract. It had a non-compete in it. One of his buddies said, don't worry about that. There's no way that any court in Missouri is going to enforce that. And he left, and his former employer sued him, and he spent tens or hundreds of thousands of dollars in legal fees and several years fighting it. And he finally won. So yeah, the guy was right. It was unenforceable, but it still took a whole lot of pain and time to get to that point. So that's why I always, like when I'm talking to residents, I always say, you've got to be comfortable living with whatever's written in the contract. Just don't assume that anything is going to go away.
And is it a good idea to spend the money on the attorney reviewing the contract, or at least yourself look at it? Like, what do you recommend?
Yeah, so for sure, absolutely, because there are things, I mean, just the same way that if you gave, one of your patients X-ray or some treatment notes to look at, they're obviously not going to recognize everything, even if they're really smart. It just works the same way. A lawyer is just going to recognize things that you're probably not going to catch. And so I know the challenges, like especially with the residents that are just graduating, most of them don't have a whole lot of money sitting around. So there are reasonable alternatives. Like at the AAO, we can't review a whole contract for somebody, but we can answer specific questions. So like if you read paragraph 12 and you don't know what it means, you can contact the legal department at the AAO and we can tell you what it means and, have some conversation at that level. Or if you need more in-depth review, we do have the names of a couple of law firms that will do a full review of a contract for a graduating resident or young associate. And it's like, $600, $700, $800. So it's not a prohibitively expensive amount. And they're firms that you would trust and would want to work with. So, it doesn't have to cost a fortune to get that kind of legal review, but I definitely recommend that before anybody signs a contract.
Yeah. And you don't have to be an orthodontist to reach out to AO. It could be any dental specialty.
Yeah, I mean, for something like that, I mean, obviously we have some benefits that are reserved only for AO members, but something like that where it's just a referral to a law firm, we'd be happy to help out and give the name and contact information.
That's awesome. That's such a good resource. And I'll tell you at the end, like Trey has amazing Instagram account where he shares such it's amazing what he does. He shares legal advice in an interesting way through reels, through videos. I don't know how he does that. He makes law interesting and easily absorbable. So we'll definitely share information so you guys can check him out, follow him, and share with your friends. Okay. Awesome. So let's move forward. We talked a little bit about HIPAA. What are the common updates right now on the HIPAA front and with the employment law? Tell us a little bit.
Yeah, so HIPAA, I would say I would definitely go back to that piece that I mentioned on social media in particular, because there's it's such a great new world for practices to be able to get out there publicly and interact with patients or provide information to patients. But I think there are a lot of kind of pitfalls potentially lurking. So, for instance, one big one is one that I touched on a little while ago, is communicating with patients over social media platforms. So HIPAA requires that all electronic communications with the patient be encrypted. And so none of the DM services for any of the major social media platforms are encrypted and meet that standard. And so even though I know that's really tempting, I've seen some really cool tools that, kind of an intake tool that works off of, say, a practice's Facebook page. When a potential new patient expresses interest in it, start to communicate back with the patient. But I think the challenge is none of those are encrypted. And so that presents some problems. That also presents some problems, as we look at like teledentistry and communicating with patients through virtual means. It's the same challenge. I know during the pandemic, when practices were closed, and a lot of them were using like Skype and FaceTime or, maybe Zooms, any of those things to communicate with patients, it was the same issue. None of those channels are encrypted. And so any of those, I can imagine practices doing really cool things using like FaceTime to communicate and check in with patients in between appointments, but it's not encrypted. So if you're going to do any kind of a video, live interactive or asynchronous electronic communication with patients like that, you need to make sure that it's a platform that's encrypted and, is advertised as being especially for healthcare providers, so that you make sure that you comply with all of that.
Can I ask you a question?
One other thing. Oh, I'm sorry. Go ahead.
Sorry, can I just interrupt you real quick and ask a quick question? So is that okay to communicate with patients on social media via DMs just about scheduling an appointment? Does that has to also be encrypted? We're not talking about any medical information. They just found us. They're like, how can I schedule an appointment? Is that okay?
That's in the gray area that the lawyers love to talk about. Um, but I'll say this: if it's somebody who has not been in yet, and the law would say you don't have a doctor-patient relationship with them yet, that's probably safer. If it's an existing patient, HIPAA is so specific that even just the fact that somebody is a patient is considered PHI under HIPAA. So, and that's why, going back to those responding to online reviews, you can't even acknowledge that they are a patient at your practice in response to an online review, because that's considered PHI. And so if you say that, you're disclosing it. So I would say with existing patients, it gets really tricky because you do have a doctor-patient relationship with them. There's like the point at which the duties of a doctor-patient relationship come into existence. That's always a gray area under the law. So, at what point, like if you're talking with a prospective patient trying to schedule a first appointment, I don't know. There's no case out there that says, so like Trey, the uber ultra, like overly safe lawyer, is going to say, no, don't do it. Trey, the business lawyer, would probably say, yeah, I think you're safe up until the point that they become a patient.
Yeah. Yeah. Okay. Awesome. Thank you so much. I appreciate it. And then you were talking about employment law before I interrupted you.
Oh, yeah. Well, no, actually, I was going to throw out one more fun thing on the whole encryption thing. So another area that I think people don't think about, those encryption requirements applying. So very common, obviously practices post pictures of their patients all the time. I'm betting probably 98% of those pictures that go up on social media are taken on people's cell phones.
Mm.
So the challenge about when you have patient photos on a cell phone is there are all these behind the scenes transmissions going on where your phone is communicating with the cloud to, back up your information and all of those kind of things. And again, that is not encrypted. So there's a strong argument to be made that if I have a patient photo on my phone and my phone backs up and stores to the cloud, that I just committed an unencrypted transmission of electronic patient information. Or
Hmm.
the other similar situation is the minute that you walk out of the practice and like you're no longer on your internal Wi-Fi network in the practice and you get in your car and now you're on cell networks, or you get home and you're on your home Wi-Fi. Once you get out of the practice, then there's transmissions going on there too. So that's why I've been really preaching to practices that if you're taking patient pictures on your phone, that's fine, but post it immediately or else get it transferred to a physical computer in the practice, a hard drive, something to where it's not being transmitted, and then get it deleted off your phone so that you're not your phone's not doing those unencrypted transmissions.
Wow, all the things you have to think about nowadays. So crazy.
Yeah, yeah,
This is incredible.
fun stuff.
Yeah.
Fun stuff
Yeah.
for sure. So to get back to your question about employment law, obviously by far the biggest change in employment law has been the non-compete situation. But another area, and again, this is where I can tell you what the last administration did. I can't tell you yet what the current administration is going to do, has been in the area of whether somebody's an independent contractor versus an employee. So the previous administration was really cracking down on employers who try to classify employees as independent contractors and get out of, some of their responsibilities on providing benefits or mandatory time off or all the other things that the law requires. And so I've had over the years, like when I mentioned residents contacting the AAO with questions about employment contracts, I've seen 2 or 3 contracts during that time where the document is titled independent contractor agreement. And then I look at it and it's an employee agreement. I mean, everything about it is an employee agreement. And so I've been telling residents, especially like, get familiar with the IRS has this 20-factor test that determines whether somebody's an employee or an independent contractor. It doesn't mean you have to meet all 20 of them. It just says these are the 20 things that a court would look at if they were trying to determine whether somebody's an employee or an independent contractor. And if you look at that list, and if your employer is telling you, hey, we want to have this independent contractor arrangement with you, and you look at that list and you're saying, no, this looks like an employee agreement to me, that's something you need to push back on before you sign that contract. And so, the vast majority of those factors have to do with how much control the employer has over the employee. So control over setting your schedule of when you have to work, setting, your patient schedule, making decisions on who are taking as patients, making decisions about, like who provides the staff that help you out, who provides the materials and supplies. All of those are the kind of things, the more of that the employer does, the more likely that a court would say their employer. But I like I said, I've had to bring that up with several residents over the years to say, I think you're really an employee. You may want to push back on this. And that was something that the prior administration was really working on. But again, I don't know yet whether the current administration is going to continue that or not.
And employers do that just because they don't want to pay the payroll taxes, but new association.
Payroll taxes, provide, many states have, requirements on benefits. The paid time off is a big one. A lot of state, like you look at somewhere like California, they've got really generous laws for an employee about if you're considered an employee, this is paid time off the employer has to give you for sick time,
Yeah.
for sick leave, for maternity or paternity leave, all of those kind of things. And employers want to be able to get out of having to pay you
Yeah.
for any time off that you need.
Yeah. Wow, this is so good to know. Thank you. Thank you for sharing that. Well, I'm going to move towards questions because we've received a good number of them. So I'm going to
Okay.
cover all of them. We're just
Yeah.
extra 8 questions while we're talking. So let's start with that. So the first question, the doctor is asking, I wanted to ask about the risks to breaking an associate contract. Kind of like a nice segue. We just talked about a contract. So the doctor writes, they have in the terms that if I leave sooner than 1 year term, I have to pay back my sign-in bonus. How likely are they to take legal action against me? Just with that
Okay.
information, what
Yeah.
what can you
So the lawyer answer is I have no idea, but I mean, because it really does come to, I mean, that's a very enforceable term of a contract. I mean, I'll say that right out of the gate, is if a contract has that in it, a court, if somebody sued you over that, a court would definitely enforce that. That's kind of falls under the general category of liquidated damages, which means that if the contract is ended or breached under certain circumstances, that it sets out kind of what the remedy is. In this case, the remedy, for leaving before the term of the contract would be that the associate has to pay the bonus back. So that's definitely an enforceable term of a contract. Now, what is the likelihood that the employer would enforce it, maybe even go so far as to sue to enforce it? You really have no idea without knowing the specific situation. What I can say is, as a lawyer, rather than have to have this big area of speculation where you don't know what would happen, we as lawyers always want to try to make the situation much more definite. So the way to make it much more definite would be to try to come to an agreement with the employer and say, I know this is in here. I'm willing to do something depending on the situation. Obviously they're probably not going to just waive their right under the contract without without getting something in return, but you have to think. I would be thinking through what can I offer the employer in return that would still be of value to them that they might be willing to agree in writing, definitely get
Yeah.
it in writing, that they will waive this term of the contract. So that could be something like maybe you have a very small non-compete in the contract, but you're going to move, you're going to move, like say the non-compete is 3 miles and you're going 10 miles away to the next opportunity, then you could say, hey, I'm willing to agree that I will not practice within the non-compete area if you're willing to agree to waive this, or I'm willing to extend the non-compete area to 10 miles or whatever it is. Just give them something of value in return so that they might be willing to waive that, and then make sure you get it in writing. The trick there is most contracts say they have a term in there. It's called the 4 corners. It means that only the words in the 4 corners of the contract are binding. Like it'll usually say this contract can only be amended by a subsequent agreement signed by both parties. What they don't want is for somebody to come forward later with like an email where the people just agree to something. It has to be an amendment to the contract. So if you're going to do something like that, anytime you want somebody to waive something that's in a contract, you need to write it up as an actual amendment to the contract. And, even if they agreed to it in an email or something like that, so it's in writing, it has to actually be an amendment to the contract.
Nice. That's really helpful. Thank you for sharing that. So another question is discuss restrictive covenant and changes. I think we talked about this, right?
Yeah, that's the whole non-compete. Yeah, restricted covenants are just another word for non-competes. One other thing I didn't mention on that, we as the AAO are in a really interesting position when it comes to that subject, because we have a whole bunch of associates and residents who, are very happy about non-competes potentially being banned, but then we have a bunch of practice owners that are not so happy about them being banned. And so, we've gotten a lot of questions, and, people were asking, like, is the AAO going to take a position on this? Which we're not. That's definitely one we just monitor changes in the law and then make sure people are aware. But the one thing I will say is, like, if you're a practice owner, even if non-competes are banned, I think there are still going to be ways to accomplish something similar. Or if you're an associate signing a contract, I think at that point it's going to transition from the restricted covenants are not going to be non-competes that are based on geography. I think it's going to be more like a non-solicitation type of agreement where the contract is going to have language that, you can't solicit obviously anybody who was a patient of the practice. I think probably people are going to try to, if non-competes go away in their current form, I think people are going to try to broaden non-solicitation and make it like family members of current patients, all of those kind of things.
Yeah.
So, even if the ban does eventually become permanent, I think we're still going to be dealing with similar issues in the future. They'll just change a little bit.
Gotcha. Gotcha. Wow. We'll see what happens. I guess we just have to kind of sit and watch the news.
Yeah.
Another question is walk us through a procedure that converts to a lawsuit, comma, a protocol. And then there's a similar question came in the chat today. If a patient approaches us with a potential lawsuit, what are the actions that we should take, both personal and professional, short term?
Okay, so those are both excellent questions. So on the first question, kind of how does how does something going on in the clinic turn into a lawsuit? And so I think, that can take different forms, but I think the common denominator is always that, patients don't march straight to a lawyer's office the first that they encounter a problem. They're going to come into your, they're going to be arguing with you. They're going to want their money back. They're going to, whatever, all of that stuff. So whatever the exact process is that a problem in the practice turns into a lawsuit eventually, the common denominator in every one of those situations is a patient finally gets so fed up that they're not getting a resolution with the practice that it eventually dawns on them to go call a lawyer and talk to a lawyer. And so that's why I think it's so important. Anything you can possibly do that's, not just remotely tolerable, like even stuff you're not really comfortable. Like, I really hate the thought of giving this patient a full refund, but if I give them a full refund, I can get them to sign a release so that they won't sue me later. It's just cutting off that progression where the patient finally gets to the point where they say, I'm just not getting what I want. And then they take the step to get online and find a lawyer and give them a call. Because once they call the lawyer, then it's like a whole different game. You got to be much more careful. You probably got to get a lawyer involved right out of the gate. You got to contact your malpractice carrier and let them know that a potential claim has been asserted, all of that. So that's really kind of the key point to stop all of that. Is nobody's pride, wants to give the patient everything they want. But to me, that's just so important to stop that progression before they actually contact the lawyer.
Yeah.
On the second question that was related to that, what do you do? So,
the patient
two scenarios. Yeah.
What are the actions we should take, both personal and professional, short term?
So I think the three steps I'm going to tell you can be triggered either. Certainly if you get if a lawyer contacts you, or even at the point where the patient says, okay, that's it, I'm calling my lawyer. The three main steps that I think are important to take are, number one, all the communications with the patient really need to be in writing at that point. Now, I know it's tougher if they're still being treated. Like if it's an orthodont, that's a different situation if somebody came in and had a cavity filled and then they're not happy about it afterwards, because you don't necessarily have to ever see that patient again, as opposed to an orthodontic patient that still has like a year left of treatment. So I know that won't work in all situations. I would say if it's somebody that's still in the middle of treatment, it's okay to discuss, like the stuff about treatment. But if you're having any discussion about the dispute or whatever the problem is, get that in writing. But get it in writing, because at that point, if there's a significant potential for a legal claim coming, you want to have a written record. You don't want the he said, she said of like phone calls or, discussions in person in the practice and all that. So number one is get as much as you can in writing. Number two is at the point that the lawyer threat either it starts getting made or somebody's contacting a lawyer, kind of appoint one person in your practice to be the sole touch point with the patient. You want all your communications with the patient being funneled through one person, whether that's you as the doctor or, your office manager or whoever. You want all the communications going through one person, because what you don't want is like conflicting things, like the patient talks to one person and they say one thing, and then they talk to somebody else and they say a different thing. So, at that point you say, okay, this person is our only point of contact with the patient from this point forward. And then the final thing is definitely make sure to contact your malpractice carrier. The first time the word lawsuit, lawyer, any of those words, the first time they come up, make sure you're in communication with your insurance carrier, because the I mean, they can be a really valuable resource to help coach you through that process. But even short of that, you just don't want to do anything that jeopardizes their ability to defend you later. Because I used to have that, like back in my law firm days, I would have situations like that where the client was trying to handle things on their own longer than they should have. And then they bring the case into you, and you're like, oh man, I really hate that you said this or did this 2 weeks ago, because that really hurts our chances on your case. Like if you'd come in and talk to me already, I would not have let you say or do that.
Yeah.
So that's the kind of guidance that your insurance carrier can provide, is make sure that anything that happens from that point forward is consistent with what they're going to need if they ultimately need to defend you in a lawsuit.
Yeah, gotcha. So I really love that second point, because so often that it becomes a kind of broken phone, right? When one person talked to them, another and another, you're like, oh my gosh, why did you say this? Why did you say this? So I think it was a genius idea.
Yeah, I mean, there's legal importance to it. There's also just like just the dynamics of human psychology. It's like the kid doesn't want what they want from mom, so then they go talk to dad, and then mom and dad are in a fight because mom said no way you're going to that party, and dad said yeah sure. It's kind of the same thing. Like patients many times will identify like good cop and bad cop
Yeah.
within a practice. So if they hear something from the bad cop that they don't like, they may go talk to good cop hoping that they hear something different.
Yeah, how funny. And so if I appoint, let's say, my office manager, then I don't communicate with the patient at all.
I would, yeah. I mean, again, I know that like if the patient's still in the middle of treatment, that's a different situation. But like if the case is finished at that point, then I would say, yeah, and
Gotcha.
push it up. And interesting point on that is, I know how the doctors are the type A personalities with a lot of pride in their professional reputation and all those kind of things. Sometimes all of that though can make you a little more emotionally, but like sometimes that person that gets appointed as the point of contact, it's better if they're not quite as emotionally invested in the situation. And that's why sometimes as the doctor, it might be better to take a step back and let somebody else handle it.
Gotcha. You got such a good point. I definitely coach a lot on that. So I definitely can see that. All right, let's switch gears a little bit. And the question is, what is the best way to prepare for transition out of practice, retirement, sale, etc., from the legal standpoint?
Yeah, so that's a great question, and one that I am not, I know like if it's an end of career type of transition, then there are some estate planning type of considerations there. Or since my background in law before coming to the AO was on the litigation side and not the transactional side, this is not my area of expertise. So my definitive advice is talk to the professionals, and with an S there on the end, to make sure that they assist you. Because what I have seen, I think most people know, I mean, obviously, like if you're considering selling your practice, that's a complicated transaction. Most dental professionals are not going to try to handle that solely on their own, but what they do try to cheap out on is just having one person handle it. So maybe they just go talk to a lawyer, or they just go talk to an accountant. And really depending on how sizable the transaction is, you may need a whole team of people helping you with that. I'm almost certain you're going to need a lawyer. I'm certain you're going to need an accountant. You may need a couple of different, you may need one accountant that specializes in kind of the due diligence of looking at, if you're thinking about buying a practice, one accountant may specialize in doing the due diligence in evaluating the deal. Another accountant may specialize in helping you with the tax issues, once you acquire the practice. So you may need more than one accountant. There may be other things involved. Again, like if you're acquiring a practice, you may need to look at, say you find out as you're having your initial conversation about the practice, they really had a bad track record with staff. Like they got sued by 2 or 3 staff that left the practice. I may need to bring in an HR specialist to
Mm.
look at things and make sure that when I'm buying this practice, I'm not buying, you know, something that's going to flare up and
Yeah.
get me later. So it's really that step of looking at who are all the you don't want to cheap out on it. Just think that one person can cover everything you need in a deal like that. It's really thinking through what are all the skill sets that I need in this deal. Oh, and then I forgot to mention estate planning too. Like if you're transitioning out of your career, then I would definitely loop in somebody who's an estate planning pro so that they can help coordinate your disposal of the practice with whatever your other larger life, kind of estate plans are.
Yeah, yeah, that's what you meant by ask, like multiple people.
Yes. Yes.
Okay, gotcha,
More
gotcha.
than one. I know everybody wants to save money on everything, but it's always easier. It's always cheaper and easier to avoid the problem in the first place rather than try to clean up the mess afterward. And
Uh,
so
Amen.
spending a few bucks in the I mean, it's like insurance. Spending a few bucks on the front end may save you a lot on the back end.
Yeah, yeah, yeah. I love that. And there's a similar question to estate planning. What are your absolute must-haves? And I don't know, maybe that's not your area. Maybe you can recommend somebody to talk to. But the question is, what are your absolute must-haves for estate planning? How can we decentralize our business from our personal assets and protect our family?
So so A, that's a great question. B, as you hinted at, that is really not my area of specialty. But I think the thing that in particular really enforces why that's another one of those kind of things you really have to make sure you talk to a professional is because state law can vary so dramatically. Like it's completely impossible to just get, even if I were an estate planning expert, it's impossible to completely give a blanket answer to that because it's going to depend very heavily. I mean, there are a lot of federal implications, tax implications, but a lot of it is going to be state law related
Yeah.
too. And so I would find somebody who is an estate planning expert that's in your state where the transaction is going on to make sure you're getting their input on a question like that.
These are attorneys. We're looking for estate planning attorney, or because you said expert.
Yeah, I mean, generally, I would definitely start there, especially with that particular question.
Yeah.
I think an estate planning attorney,
Yeah.
so you're going to want to start with um, frequently that question also needs some accountant, like financial planner type advice too. The attorney can tell you, I can tell you what you need to do legally to accomplish whatever your goal is, but the financial planner needs to help you establish what the goal is. Like, I want to save up this amount, or I want to be able to pass this on to my kids,
Yeah.
or maybe one of my kids is remaining in practice at the location. There's just a
Yeah.
lot of different angles, and the financial planner is the one who can help you with the big picture goals, and then the estate planning lawyer helps you to draft the documents and do all the other things to get to those goals.
Yeah. Yeah. That's sounds like a team. We need a team again.
Yeah. Unfortunately, I know that's more money, but
Yeah.
it's just the safest route.
Totally, totally. Okay, we still have a couple of questions. Let's fly through these. The most challenging case and how you helped win it. Ooh, that's a juicy one.
Oh, wow. Okay. So I would love to give you like a dentistry specific case. The trick is that I didn't handle like dental or malpractice type of cases in my previous law firm role, but I can give you a case that I think directly applies to a lot of what we're talking about, even though it wasn't specifically a dentistry case. So this was a case where I represented a building owner. So he had bought this building and he wanted to develop it into condos. So he hired a general contractor, all these subcontractors, and you know, probably not surprisingly, especially with his personality, things didn't go the way he planned. Things were running over budget, all of these kind of problems. So he wants to sue the general contractor and the subcontractor. So he comes into us and he is just, I mean, he's like a super type A, overly aggressive personality anyway. And he's just so furious about the whole situation. Like every time he starts talking about, the veins start popping out in his neck and he turns red. And all of that, just as much emotion as you can possibly have about a business situation. He's that fired up. And so his instructions to us were win at all cost. I don't care. I don't care what I have to spend on this case. I don't care what I have to do. I just want to bury these guys. I'm so furious with them. Win at all costs. So he says that. So we, doing what we're legally required to do as lawyers, we obey his instructions and start. So he's totally on board with this scenario until the legal bills start to come in, and then he's mad at us now. So we end up, we're in a mediation where we're trying to reach a resolution with one of the subcontractors, and the mediator is going back and forth between the two parties trying to negotiate it. So he finally comes back in, and it's obvious at this point the case is not going to settle. So now my client is sitting there just furious with it. That he hates the opposing party, but he also is furious with me, with our firm, because of the legal bills. And then the mediator comes back in and says, okay, he said that was his final offer. He's not accepting any offer. So I think we're done here. He said, I'm going to go back in the other room and keep him busy while you guys sneak out of the building, because if he runs into you guys on the way out, he's probably going to want to beat both of you up. So it just, totally turned into this mess. So that's why I always say, like my point earlier about if you're really emotionally invested in a situation, to take yourself out of it. I think that's the universally applicable rule, is that emotion so many times drives any of these kind of legal situations. It's a dispute with the patient. Maybe you were in a business deal for a practice and the business deal goes bad. So much of the time, it's the emotion that's really driving the decisions, and emotions make horrible business decisions. So whatever you need to do, even if it's completely removing yourself from the situation and letting somebody else handle it. If you're that, like that guy that was my client, that is absolutely what he should have done. He should have gotten one of his employees to take ownership over the case and take himself out of it, because emotion always makes horrible business decisions.
That's amen to that. That's literally what I teach. The fundamentals of No Stress DDS Mastermind is how our thoughts create our emotions, how to manage them, because they drive all our actions and all our results. So I love that you're bringing this up. See, guys, it's not just me, an attorney is saying this too.
Yes, there you go.
Trey, we still have a couple questions, but I want to make sure that you can share your mission as well. Can you stay for like 5 minutes late, or will you have to jump off?
Yeah, no. I can.
Will you be able? Okay. Yep. Thank you. Thank you so much. Okay. So I'm going to read a couple more questions here. Just want to be mindful of everybody's time. All right. Here's a longer question. What are the legal boundaries for responding to Google reviews from patients while staying HIPAA compliant? Specifically, can we confirm that a patient received treatment? It's a no. You already said that. At our office, if they mention it first, though, that's a good question. Also, what specific language should our media consent form include to ensure we have full legal permission to post patient photos or testimonials on social media and marketing platforms?
Okay. Great question. So the first one, I love talking about the how to respond to reviews because it's such a common question. So the rule of thumb is, so that as the question hinted, even if the patient has already said that they were a patient at your practice, if you say it, you're still making an unauthorized HIPAA disclosure, because HIPAA says that a patient authorization has to be specific and in writing. So them saying it themselves in the review is not an express written authorization for you to say it. Okay. So if they didn't authorize you in a written document somewhere, then you can't say it, even if they've already said it. So the rule of thumb to avoid the problems there is that for both positive and negative reviews, your response can acknowledge the review itself. It just can't acknowledge that the patient was a patient or any of their health information. So I'll give you quick examples of what that looks like. If it's a good review, patient says all these glowing things about your practice, then in response, normal human reaction is to say, thank you so much. We loved having you as a patient, but now you're violating that rule. What you can say is, thank you so much. We love hearing great stories like that. Or thank you so much. We love reading great reviews like that. Something like that, where you're only acknowledging the review itself, but you're not acknowledging any of the factual information. You're not repeating any of the factual information that was said in the review. On the negative reviews, something somewhat similar. Again, you want to acknowledge the fact that they left a bad review, but not acknowledge any of the factual information in it. So we always recommend saying, it appears there's been a misunderstanding. Please contact our office to set up a time to discuss. So you're only acknowledging the bad review itself. You're not, addressing any of the information in it. The other thing that's really important with the bad reviews is get it offline as soon as possible. So by saying, please contact our office to set up a time to discuss, that's your invitation to get it offline. What that also does, if the patient comes back and says, well, yeah, but, and this says a bunch of other stuff, you say, as we said, it appears there's been a misunderstanding. Please contact our office, set up a time to discuss. Other people are reading that. It looks like you're the reasonable one saying, like, hey, please come in and talk to us. It makes the patient that's just, spouting online at that point, it makes them look a little less credible.
Yeah.
So then on the question about the release, I mean, definitely a properly worded HIPAA release will take care of most of those kind of things, as well as using the picture and all of that. The big thing about the release is because you only have authorization if it's in writing and specific by the patient. You just want to make sure that your release is worded as broadly as possible. So like if you're an AAO member, we do have an example that's up on the member website under the legal resource section that you can get, that's very broadly worded, would take care of nearly everything. For anybody else who's not an orthodontist but is a member of a different organization, I'm sure they probably have similar documents. So I think the key there is, don't just try to make your own, just use, somebody's example that's worded very broadly like that. Make sure it covers every possible situation.
Nice, nice. That's so helpful to know. Thank you. Thank you for answering that question. And a little bit more on social media, since I know you enjoy talking on this topic. Me too, because I'm learning so many things that basically we are kind of, I don't want to say stuck, but there are few things that we can actually share and say online sounds like it. And the question was about, remember how you mentioned that communicating with patients or potential patients on social media is not a good idea because it's not encrypted, including, virtual consultations via Zoom or FaceTime and things like that. So the question is, do you know a good company that we can use that encrypts for virtual check-ins? Do you have any recommendations? And is a signed document okay, saying texting is okay, make scheduling and text communication is okay? Like, can we give them some document to sign where they say it's
Yeah, so that's that. Okay, let me hit that second one first. That's a really interesting question because a patient, the law is very clear that most of the patient's HIPAA rights about like not disclosing private information, it's very clear a patient can waive those rights by signing an agreement. The encrypted transaction requirement of HIPAA, because that doesn't belong to the patient, that's just like a HIPAA rule. The law is not clear yet on whether a patient can waive that or not. So that means you could even get something signed by the patient saying, yeah, text is fine, whatever. It's not totally clear at this point whether that would take care of it or whether HHS might still try to enforce that. So
yeah.
that's why I think it is much safer just to make sure that you're using communication platforms that do, include the encryption requirements. The second question about a company to use, I am not an expert in that area. What I can definitively say is, like with the AAO's annual session coming up in a couple of weeks, I am certain I could probably walk around the exhibit floor and talk to 3 or 4 companies who do specialize in that. So I'm sure wherever your marketplace that you're looking for somebody who provides like that, I'm certain I know that there are good companies. I just don't know specifically what they are.
Gotcha. So just go to our local conference. I know there's one in Philly happening like literally in weeks, and definitely
Yeah.
going to be companies that do that.
Yeah. Yeah.
Yeah. And I was just thinking the same thing with Yelp or Google reviews. Can we have the patient during the consultation say something that says, we can, like, basically you waive your HIPAA rights, and I don't know, maybe different language, but like basically we can acknowledge that you're a patient of record if you ever write us a Google review. Is that, or Yelp review?
Yeah. Yeah. No, you definitely can do that. Yeah.
Okay, that's so good to know. Okay, awesome. Should we go back and change old review responses or just change from here forward? Like if we, like in the past, identify the patient?
So that's an interesting question because even if you go back and change the version that's currently publicly available, there's all these great things like the Wayback Machine or whatever it's called. There are like snapshots of the internet at a certain time that maintain all of this stuff, even if it's not, like if you change your web page for your practice, somebody can do some research and find a previous version of your web page because it's still out there. So it won't necessarily fix, like, if it's like, oh, oops, we violated HIPAA on that one. You don't just erase it completely by changing what's currently seen by the public. But what you may do is, if you get a lawyer or somebody that's just looking around and they don't dig so deep as to look at prior versions, they're only looking at what's up there currently, you may prevent somebody from, finding that out.
Yeah.
It would take, you have to be much more intentional to find prior versions of a web page, than just to see what's up there currently. So if you change what's up there currently, the reality is it's probably going to avoid many instances of where a violation would be discovered.
Yeah, so it's not a bad idea. So what you're saying is that it's a good idea. It's not a bad idea to go change, but no, if somebody wants to dig, they will find what was initially said. So basically,
Yeah.
that doesn't exist. Everything that you put out on the internet stays there forever.
Yes.
Can you imagine
Unfortunately.
that? I know.
Yes.
Oh God. Okay. Let me see another. I think there's only one or two questions. Do you typically recommend settling out of court due to costs, etc.?
Yeah. Short answer is absolutely.
No.
Because litigation is expensive. So as a litigator, I always told people the best litigation strategy was to not litigate at all. It's just, there's so much uncertainty. Cases that you think are cut and dry and are, should be a simple, they will end up taking way longer than you expect. They'll end up costing way more. The other uncertainty is 18 years of being in court. I saw judges and juries make the most irrational, ridiculous, no rational, logical basis whatsoever kind of decisions. And so and that's not to say they all do. I mean, there are amazing judges out there, there are great juries, but there are a lot of not great ones too. And so it's just, all of those are layers of uncertainty. And so that's where, when I talked about earlier that the lawyer is always trying to get you to a point of certainty as quickly as possible, settling is just a way to do it. So, that goes back to well, I don't think I did anything wrong, so I don't want to pay a dime on this case. Well, what if I tell you that if you pay $10,000 on this case and you just get rid of it, that saves you from potentially having to pay, $50,000 or pay $30,000 or $40,000 in lawyer fees on down the road. So that's where, again, you have to have a rational, non-emotional decision maker sometimes making a decision on, it's just safer, it's just more predictable for us to settle this instead of risking it at trial.
Yeah. Amen to that too. My husband does medical legal, so I constantly see that. Another question just came in. What is the average claim on an orthodontic lawsuit and on dental?
I don't know the answer to that, but I know where I could get the answer. Like here at the AO, I could pick up the phone to the AO insurance company and Liz Franklin, who handles its primary point of contact on claims, and she could probably give me more information than I would ever want to know. My suspicion is, from knowing the way that, what makes it hard to answer that is, are you talking about like dollar value of cases that are settled or dollar value of cases that are actually litigated? My understanding is that, like, the cases that the AO insurance company handles, the vast majority of those are settled. I mean, there might be a lawsuit filed, but they're going to settle it before they go to trial. So those kind of settlements are going to be, as compared to like other healthcare, other like medical lawsuits, people don't typically die from orthodontic treatment. People don't die. I mean, there are a few cases, if you involve like sleep dentistry or some things like that, and that's where I have to separate out too, orthodontic treatment from other, because obviously, like, if you're talking about sleep dentistry and anesthesia, that gets into a whole different world of potential damages amounts as opposed to like standard orthodontic treatment. I think the vast majority of orthodontic cases are going to be relatively low. I mean, doesn't sound like low dollars, but
Yeah.
5, 10, up to like 30, $40,000, which if you're just writing a check out of pocket, that's a significant amount. But compared to, medical judgments or a case where somebody dies from anesthesia or something like that, that gets into millions of dollars.
Yeah. Yeah. I always like tell people 15,000 because I'm just calculating like the implant, the bone graft, the crown, because the worst thing that's going to happen is a loss of a tooth. There's no loss of a limb, there's no loss of a life, right?
Yeah.
So yeah.
Yeah. Yeah. I think absent, that's kind of like anesthesia or those kind of things, that's a pretty fair rule of thumb.
Yeah, yeah, yeah. And when you mentioned sleep medicine, because a couple of folks here are doing sleep medicine, but in terms of, sleep assessment or appliances, like we're not really doing anesthesia. What do you mean by involving anesthesia in sleep medicine? Like what
Oh no, I meant like where people like oral surgery or any other dental cases where people are under either, general anesthesia or
okay.
or I'm drawing a blank on the term, the partial like light and heavy sedation
Okay,
or
gotcha. I see.
general
Yeah,
anesthesia. So like oral surgery or,
yeah. Not sleep
somebody's
medicine, but putting to sleep the patient. I see what you're saying.
yes. Yeah,
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 yeah.
yeah. Gotcha, gotcha. Okay, that's a little bit different.
Yeah.
Awesome. All right. I think we you've answered all the questions. Thank you so much. We've got a lot at
Yes,
the end.
absolutely.
And I
Absolutely.
really want you to try to share a little bit with everyone the mission that you are on and what you with the advert of AI, like we talked about, and all these medical appliances, like in orthodontics, for example, the Smile Direct Club, right? And there's so many in general dentistry, right? Like the dentures just take molds and the AI creates them that are kind of pushing doctors out, right? Like these multi-million-dollar companies are trying to be direct to consumer and take our jobs away. So can you speak a little bit on what your mission is, what you are helping to do, and how we can help be a part of that?
Yeah, definitely. So we got involved in this at the AAO because, as you mentioned, so when we talk about direct to consumer dental treatment, orthodontics, was the first place that showed up through like a Smile Direct Club and some of those other companies that were doing orthodontic treatment direct to consumer by mailing people aligners. And so we at the AAO were I think the first area of dentistry to encounter that. And unfortunately, it has spread now. I mean, we've seen a little bit of a lull of activity in direct to consumer orthodontic treatment, but all you have to do is get on Google and find lots of companies that are doing direct to consumer dentures or partial bridges and lots of other basically any kind of a dental appliance or I mean anything you can put in somebody's mouth, somebody is or will soon be doing a direct to consumer version of that. And so that we really consider that to be, kind of the existential question for dentistry because it's cutting the doctor out of the treatment process. And it's not really a surprise why a company would want to do that because any healthcare, the doctor is the most expensive piece of the healthcare equation. And so to the extent that you can cut the doctor out of the treatment, then you get a major cost advantage. And so what we're really concerned about is that as AI develops, as other technologies continue to develop, we're only going to see more and more of this. And so we have been working very hard on getting laws in place at the legislative level, state legislative level. So this is not just dental board rules. This is getting state legislatures to pass bills that require that a patient, the touchstone for us, really kind of the baseline that you can't go below is for a patient to be seen in person, examined in person by the dentist, for orthodontic treatment, they absolutely have to have x-rays taken before you start treatment. Once treatment starts, then it really is up to the judgment of the doctor about how much remote technology is used to communicate with the patient. But that's really the baseline for safe and effective patient care is to be seen in person by the dentist before treatment starts. So we've been really happy that we've had bills passed in 4 states now, Nevada, Florida, Illinois. So far this year, Utah. We have several other states that bills are pending this year where a patient has to be seen in person by the dentist, except for things like an emergency care situation. So if a patient, has a toothache over the weekend and they need an antibiotic and a painkiller until they can get into the dentist on Monday, or like a public health kind of application, like a hygienist going to a nursing home, we don't want to interfere with those kind of treatments. But if anybody's doing any kind of irreversible dental treatment, we want it to be a legal requirement the patient's seen in person. So in passing laws like that, that is definitely not just an AAO out on its own kind of endeavor. We need, the entire dentistry coalition and those places that we've seen the bills pass. We absolutely have had the strong support from the state dental association, strong support from other groups in dentistry. So I don't have a specific ask or an action item at this point in time, but we're just trying to raise awareness about this issue so that people recognize that, if you start to see something going on in your area or in your field of dentistry, your specialty, you say, hey, hold on a second. I recognize that is a company trying to cut the doctor out. Contact us at the AAO, contact your specialty organization, whoever it is, and get us involved, because we are definitely working as a coalition to try to pass laws to protect patients from this.
Amazing, amazing. So we will just reach out to, like you said, anybody either at AO or like Cal or Dental American Dental Association, ADA, or our constituents, and let them know that, hey, these appliances are popping and we're not sure if doctors are watching over them.
Yep.
Yeah.
Yeah, definitely.
That would be
Definitely.
helpful. And yeah, that's when you and me spoke about this. I mean, I knew that these things exist, but I was kind of shocked with what these companies are doing, how things are taking over. So
Yep.
to be a part of this mission. And thank you so much for coming and sharing that with us. And we can
Yeah.
connect on social media, right? You're an ortho attorney.
So my primary home is Instagram. It is
Yep.
the Orth Attorney, ORTHATTORNEY, the Orth Attorney
Yep.
on Instagram. I'm also on TikTok, but Instagram is really my home because it's easier to connect with people and comment and DM and all of those things on Instagram than it is on TikTok. So yeah, so if all this stuff that we talked about today either interests you or you're so scared by it that you need to learn more,
Yeah.
definitely follow me, because I try to post regularly on these kind of legal topics.
And Trey is amazing. Ladies, the CEO of the American Association of Orthodontists is on TikTok and Instagram. This is amazing. I'm so proud of Trey. He's the most amazing human. I met him in person. I mean, just thank you so, so much for coming here and just answering the rapid fire of questions that we had put you through, and give us all the latest updates, and spending over an hour, almost an hour and 17 minutes with us. Really, really
Yeah,
grateful. So much appreciate your time. So valuable. Extremely grateful. Thank you.
absolutely. No, thank you for the opportunity.
Absolutely. Well, have a beautiful day. Everybody stay safe. I know you and me are in the tornado areas. So I hope everybody else is doing okay. Once again, maybe we'll have you again. It was amazing. Thank you. Thank
Okay,
you so much.
sounds good. Thank
Have a
you.
nice
Yep,
afternoon.
bye-bye.
Bye.